anyways, thank you everybody that's online for attending and participating in this webinar, which is going to go through, as is on the page that you're looking at, understanding the critical implications of Bill 60 for the construction companies and stakeholders. By way of introduction, I am Mike Carter, the CEO of the London District Construction Association. I am also the treasurer of the Ontario Construction Association Alliance, which is 7 LCAs across Ontario, under the trade name that folks would mostly know as Link to Bill. So Bill 60, I would say, is improvements to the Construction Act. It was a statutory review, and it's to reflect and make better what we've learned from the Construction Act, which was a very sort of revolutionary change in law. It is, and I will say this for all the contractors that are on the call, because I deal with a lot of them on a range of things. I will tell you all this: it is the law of Ontario, and no matter who the buyer is or where they're headquartered, whether it's in Ontario, Quebec, United States, England, China, makes no difference. They have to construct in Ontario under the law of Ontario, and no contractor should ever doubt that. So I'm not going to introduce everybody, but I'll introduce Clive very quickly. Clive is the past CEO of OGCA. He is also a special advisor, the special advisor to both myself and the board of directors of the LDCA, and that is in 2 specific roles. He handles disputes between members so that we don't have to recuse ourselves or any of that kind of stuff. It's completely then standalone, independent, and he provides executive leadership for primarily newly formed companies who, great electrician, but doesn't know the law, and they often, as you would know, get themselves into some difficulty because of that. And so we're very thankful to have Clive. We're also very thankful to have Glenn. He has been involved in both the Construction Act and now Bill 60 in a very deep and detailed and positive way, reflecting the needs of the industry. And he has a long history of help. He does these webinars on an ongoing basis. And I, for everybody, publicly thank him for all of his efforts. So the rules of the meeting are very simple. We are recording. That's so we can provide both a video chapter presentation at some point afterwards, and also provide just an audio. And everybody except for presenters is not video, not audio. And if you want to ask questions, the only questions that will be flowed through to Glenn and Kathleen are via Clive. So in your chat, just identify Clive as who you're asking the question to. And on that, I'm killing my camera, just killing my mic, turned on the audio, and I'm handing over to Clive, Glenn, and Kathleen.
Thanks very much, Mike, and welcome everybody. This, of course, is a major event in our industry. The first Construction Act was earth-shattering, changed the way we did business. And as we were discussing earlier, Ontario was the first province to achieve it. And I still believe we have the best system. As I've been involved with the other provinces, I think Ontario got it right. And you're going to hear why we got it right, starting with Kathleen, who I understand is a London lady as well, and her family has a company there and members of the LDCA. Glenn, Mike has already told you, and I've worked for many years with Glenn, and I can assure you he really does know this and was responsible for a lot of the information that went to Duncan, who did the review and submitted the proposals to the government. So enough said, we will carry on, and I'll turn it over to Glenn and Kathleen.
Well, thanks very much, Clive. And I just want to say what a pleasure it is and an honor to be a part of this session. It's, as Clive said, a really exciting time to be in the practice of construction law as we see all these changes coming into force, and we'll talk about the timing and what's happening. Just take a moment to introduce Kathleen Gregus, my associate who works closely with me here at our firm, Weir Folt in Toronto, and has helped in the background on a number of these initiatives, including taking what we've done in Ontario and help export that out to the province of BC, who, as many of you know, this past year introduced its own version of prompt payment and adjudication legislation. So we're going to now start working our way through the presentation, and I just want to start by laying out what we're going to be talking about. So we're going to begin with a bit of a history lesson. That's where we'll start, about how we got from where we were to today. There were a number of steps along the way, and it's important to kind of put this reference in the chapter heading for today's session, Bill 60, in context. What does Bill 60 do? What are some of the other bills, and how did we get here? We'll cover that. And then there are really three big blocks of topics that we're going to talk about. The first being the changes that were made to the construction lien process and holdbacks and timing of liens, and how they've been affected by the most recent changes. Then we're going to talk about the prompt payment process that was introduced back in 2019 and what some of the issues were about that process that were identified that have now been addressed in the most recent changes. Then we're going to turn our attention to adjudication and how there are improvements, tweaks to the adjudication process that the latest legislation is addressing to help make that system much better. And finally, we'll talk about some miscellaneous rules, including the transition rules. How does this law and some of the changes we're going to be talking about ease into effect? So that's the approach. As we get to the end of each chapter or segment, we'll open it up for a few questions before moving on, just so that people can get any questions or concerns addressed along the way. So we're just going to, as I said, start with a bit of looking back in history, a bit of a journey through time. Starting a little over a decade ago is when this whole process started, when the Construction Lien Act became the subject of a very comprehensive review that was undertaken by a couple of senior lawyers, Bruce Reynolds and Sharon Vogel. They were hired by the government of Ontario to crack open the old Construction Lien Act and look for ways of improving it. And there were a bunch of reasons for that. The act was first passed in 1983, so it was very, very long in the tooth. It needed a lot of updating. P3 projects were never mentioned, for example, in the act. They needed to be addressed or brought into the act. All sorts of other questions were being raised at the time about monetary amounts, but really the focus was, how do we ensure the flow of payments in construction projects? There is a lot of concern about how much money was being caught up in projects where payment terms were extending out 90 days, 120 days, and it was really choking the industry. So the flow of payment, keeping projects moving, these were all sort of the objectives, the goals of this review that was undertaken. And what it led to is a series of recommendations. Ultimately, there are 100 recommendations or so that the review led to, and the review that they undertook included consultations with industry, but also a working group. I was part of the working group at the time, and it introduced a bunch of new ideas. And I'll just quickly go over them, because these are all ideas that got introduced as we'll see, they've now been tweaked as of January 1st of 2026. So this bit of a history lesson really leads us to where we are today. First of all, the lien period was extended, of course, to a 60-day period. Termination of the contract was something that was introduced. that had never existed before. What happens if an owner fires a contractor? What's the process? The Act really didn't address that clearly. But the single biggest change in terms of the old Construction Lien Act was the treatment of holdback. And the way the Act was worded is holdback was optional, effectively, whether it was released by the owner at the end of the job or not. It only said the owner may release the holdback. It didn't say shall. And so one of the biggest changes that was recommended and adopted was the changing from may to shall, making the release of holdback mandatory, subject to some conditions, which we'll come to. The other thing about holdback was the introduction of optional annual and phased release of holdback. The ability to release holdback once a year on a long project, and the ability to release holdback in phases of a project after one tower is finished before the other tower is complete, for example, on a multi-tower project. That kind of thing. So these were new ideas, including adding P3 provisions, adding security requirements for public projects, requiring mandatory performance bonding and labor material payment bonding on public projects, and enhancing the trust provisions that existed in the Act about the handling of money and the requirement that all the money in a construction project stay within that project and not leak out the sides. So proper project accounting requirements were introduced. So these were all the recommendations, and they led to changes, which we'll touch on a few of. But ultimately, the biggest single thing that leads us today in terms of a concrete recommendation was recommendation 100, which is that a 5-year review be undertaken. Everybody recognized that this kind of comprehensive update of the law, introducing all these new provisions of prompt payment and adjudication and all the other moving pieces we're going to be talking about, wouldn't be done perfectly, that there would be problems, issues, concerns as it's implemented, and it will lead to the need for an update. And that was contemplated in the report. So let's just walk through the timeline that takes us from this report to now. It started with the report being delivered, that striking the balance report with the 100 recommendations, in April 2016. After that was submitted to the Government of Ontario, there was further consultation, drafting of legislation, and finally, in December of 2017, the new Construction Act had been drafted and was passed unanimously by the Government of Ontario. All parties agreed to this act being passed, Bill 142. And it was implemented in 2 stages. The first stage were all the changes to the lien procedures, the holdback requirements, and a bunch of other things, bonding and so on. And that all came into force July 1st of 2018. And then there needed to be a period of time for everybody to get ready for prompt payment and adjudication. We needed to create an adjudication authority and so on. And that required more than a year. And finally, October 1st, 2019 is when those rules came into effect. Okay, so as of 2019, all the changes that have been recommended were implemented in a statute and in regulations, and were being used from 2019 forward for new contracts after those dates. So then we're into the period of time where we're all working with this new statute and finding the problems, finding the drafting ambiguities. Prompt payment certainly helped with the timing of payments. Adjudication started to get more and more traction as it was being used by parties to contracts on projects that got into disputes. They turned to adjudicators and get disputes adjudicated, and the number of adjudications that took place continued to rise, and they continue to this day to increase. But there were still problems. So finally, between October and of 2019 and 2024, during that 5-year period, a bunch of work was done to solve the existing problems with the first version of the Act. And part of that involved, and as was mentioned, my involvement on your behalf, on behalf of all the local construction associations, members of COCA, and also the CDAO, the Construction Design Alliance of Ontario. I was asked by all these groups to put together a report for the government to make a series of recommendations how to improve the original version of the Construction Act, the 2017 version, how to make it better, work better, fix some of the gaps and problems in the laws. So I put together a report in the summer of 23 that had over 85 recommendations, submitted that to the government through the fall of 23. They looked at it, became educated what the issues are, and in early 24, they hired a senior experienced lawyer, Duncan Glayholt, to do a consultation and report based on many of the recommendations I brought forward, and that was called the Ontario Construction Act Review, or OCAR, and that took place through the spring and summer of 24, and then finally in the fall of 24, Duncan's report came out, and new legislation was put forward in November of 24 to address many of the changes that needed to be made, capture them, and fix the problems. And that all got passed in the legislature in a week from submission and first reading to passage. So by the early November of 24, many of the things we're going to be talking about had been passed as fixes to the old, now 5-year-old Construction Act. But it didn't come into force then. It was put on hold, first of all, because regulations had to be drafted. Secondly, we had a provincial government or an election that required us wait for the government to be reelected in the spring of 24. And then, or 25 rather, and then something else happened, and that is the realization that there were some problems with Bill 216, the law that's on hold, and those problems should be fixed by further legislation before the whole thing goes live. And that's what Bill 60 is. Bill 60 was introduced just this past November, just a little over 6 weeks ago, and got passed. And what it does is actually fix a couple of issues with Bill 216 from the year earlier to make sure that what goes live works. And that's just happened. 216 from the previous year and 60 together are now live as of January 1st, 2026, start of this year, just a couple of weeks ago. So that's kind of a long history, but it gets us to where we are. So today, we're going to be talking about the changes that are in effect as of January 1st, that are the culmination of the recommendations that led first to Bill 216 and then the subsequent additional changes that Bill 60 introduced that got us to this point. At the end of it all, what we've got is a much better act in the way it works than it was when it was first introduced way back in 2017. But I won't say it's perfect, and we'll flag some of the issues that will still need perhaps in the future to be addressed, because many things were fixed, but not everything. So the way we're going to proceed is, as I said, in 3 chunks. We're going to start with the Lien modernization piece, as they called it, what dealt with lien periods and holdbacks and so on. But the specific changes that needed to be made to the original 1.0 version of the Construction Act that have now led to what I'll call the 2.0 version as of January 1st. And to do that, the way we're going to proceed is Kathleen will describe what the problem was with what was done, how it was identified, and then I'll jump in and explain what the solution was, and we'll kind of move through it on that basis. So why don't we start here, Kathleen, with this issue?
Everyone, thanks for the introduction, Glenn. It was one of the awesome parts about this presentation, from my perspective, growing up, coming from a construction family, is the the focus on practicality. So hopefully what we're able to highlight is that these changes are really important and have really practical impacts on your projects and your businesses. And so the first one that we want to talk about is this definition of contract price. So the Construction Act, as it was originally amended, included a definition of contract price that functionally didn't really work. And this is because many of the threshold requirements and concepts in the Act turned on this definition. Unfortunately, though, as many of you probably are intimately aware, given the nature of the contracts that you enter into and the projects that you work on, is a lot of contractual arrangements don't actually have a contract price, or there is no fixed contract price at the onset of the project. And so having these really important concepts like mandatory bonding turn on a definition that functionally doesn't work or doesn't even exist didn't work. And so, yeah, we have this problem where construction management contracts, for example, cost plus contracts, for example, IPD, they didn't work because this definition didn't exist or didn't functionally work.
So, and as Kathleen mentioned, bonding, I already mentioned in passing that mandatory bonding on public projects was introduced as a requirement with a form of bond and so on. It was required for projects with a value over 500,000. Well, at the start of a project that didn't have a fixed price, how do you know that you're over 500,000 or not? So the recommendation was that you introduce a new definition or an additional definition that is based on, in those cases where you don't have a specific price agreed upon at the outset in the contract, that you use a reasonable estimate of the cost of the work that's going to be supplied or some other definition. And you'll see a recommendation, it has number 1 beside it in the slide. That was my, out of the 86 recommendation, I think it was, my recommendation number 1, the first one I addressed was this issue of contract price and recommended that it be amended to add additional definition to deal with those uncertain contracts where there's no fixed price at the outset. The good news is the statute was amended, and by amended either in Bill 216 or 60. In most of the cases, these are Bill 216 changes that were made a year ago, but put on hold for a year that are now in effect. The definition was amended to reference additional wording in the regulations for contract price, for those circumstances where you don't actually have a fixed contract price, but you need something for contract price. And so that was done, which is great. But if you return today to the regulations attached to the Construction Act, you would not find any such definition because they haven't worked it out yet. So that's a TBD, open exercise to come up with this additional wording that's required to make things work. So stay tuned for that. So after that exciting lead-off point of contract price, we're going to get into more substantial ones, but we just started with number 1 because it was the very first thing in the definitions we ran across. The rest are a little more interesting than that one. So why don't we talk about the issue, Kathleen, about design professionals that was addressed?
Yeah, so one of the really interesting parts about the construction industry is you have all of these different stakeholders that interact on a project that might span really long phases. And those phases might precede, sometimes by years, the actual putting a shovel in the ground, which you guys would know. And so one of the problems with the pre-2026 version of the Construction Act is design professionals and other actors, so architects, engineers, other professionals providing pre-construction services could assert a lien if they supplied services that enhance the value of an owner's interest in the land. But that said, there was a lot of cases where no physical improvement had taken place yet or been made yet. And so it became really difficult to determine whether those pre-construction works were in and of themselves enhancing the value of the land. Conceptually, that's a hard thing to figure out. And so this led to a lot of uncertainty, both in terms of whether design professionals had lien rights and whether certain pre-construction work it gave rise to lien rights. And so it left us really wondering and in a state of uncertainty and having to evaluate on a case-by-case basis whether or not those services were actually improving the value of the land and giving rise to specific legal rights, not just related to liens, but also rules related to prompt payment and holdback and different rights that are established under the Act.
So when you have services of the kind Kathleen just described being performed by people before the start of construction, where we recognize the construction project is the improvement, are they supplying to an improvement when the improvement hasn't started yet? This is the conundrum, the way the Act's structured. It's a timing issue. You don't know you're going to be supplying to an improvement until the improvement starts, and that's fine. But if it hasn't started yet, do you yourself, as one of these early suppliers of services, architects, engineers, do you have lien rights of your own? So it's been a problem for a long time. And the recommendation was to get this fixed up. Courts have often commented on what a mess this legislative piece is. So what they've done in the new Act, I'll call it the new version of the Act, or the newest version of the Act, is to create an interesting switch in the onus of who has to prove what, because the Act says that if the architect creates a design that itself enhances the value of the project, then they have lien rights prior to the start of construction. But the onus was on the architect to prove that was true. Now they've switched it and said if the owner is holding holdback from the 10% statutory holdback from the fees of the architects or engineers, then the assumption is they're doing something that is worthy of granting them lien rights. So if the owner's holding holdback, the assumption is they have lien rights. If the owner's not holding holdback, then they have to prove what they've done added value. The only way to get around it for an owner is to demonstrate that what they did didn't add value to the project, but that's at least shifts it on to the owner. So that is going to be a very interesting switch of who has to prove what going forward. Because the idea is, if you're holding holdback from design professionals as an owner, the assumption is they've got legal rights, and that's why you're doing it. So if you're not doing it, fine, they don't have legal rights. So long as you put them in the position of having to lien because you're keeping money back from them, then they should have the right to lien. So it's kind of an interesting, somewhat elegant way of tackling this very challenging conundrum that Kathleen was speaking about. So let's move on now to talk about the improvements to the concept I'd mentioned of termination was introduced.
So what we want to talk about with respect to this one, this kind of requires thinking a little bit about the history. So in 2018, when the Act was amended, it provided that when a prime contract was terminated, either the owner or a contractor or another person whose lien rights are subject to expiry, they need to publish a notice of termination in the prescribed form. The form that was prescribed was Form 8. And on that form, it had to include the date on which the contract was terminated. And so then that had to be published in something like the Daily Commercial News, or we have some more now where these can be published. And that was really important because the 60-day lien period for the terminated contract was triggered upon the completion of the contract. And so we have this problem though still, or we had this problem where the Construction Act was amended in 2018, but it didn't specify when the notice of termination actually had to be published. And so that meant that there were situations where, because there was no stipulated time frame, parties would wait a really long time to post the notice of termination. And then that would lead to situations where by the time the notice of termination was posted or published, the lien period for subtrades on the project could have already expired. And so it was really undermining the purpose of this whole publication process of trying to get the word out that this contract had been terminated.
So the answer then would be to introduce some timing requirement requiring, following the termination of a contract, that this notice that the contract's been terminated, which is an existing notice, that it be published within a certain fixed period of time. That wasn't in the Act, as Kathleen said. It should be added to the Act, and that was one of the other recommendations. And I had proposed, within 2 weeks, 14 days, there should be publication of this notice of that the contract's been terminated, because the whole point is to let everybody involved in that project all the way down the construction pyramid, the subcontractors and suppliers, know that the prime contract had been terminated and their own legal rights to lien the project are starting to run out. So why don't we do that? So the good news is that they've now introduced a timing requirement for the publication of that notice, a 7-day publication period. And that publication has to be done, as Kathleen said, on one of the authorized websites, like, for example, Link to Build, that can accept these publication notices. So that will have to be done 7 days after the date that the contract was terminated. And then the important thing is the lien period starts to run from the date of the publication, not the date of the actual termination, but the date of the publication of the notice is when the lien period starts to run, the 60-day period from that point, in cases where there's been a contract termination. The one asterisk with a little footnote I want to make is, unfortunately, the wording of these new provisions is a bit awkward, and it's still to this day a little unclear who is to publish. And it's also a little unclear what happens if nobody does publish, despite the requirement to publish. What if nobody does? The who, it says one of the owner, contractor, or subcontractor effectively must publish. Well, which one is going to do it? The owner thinks the contractor is going to do it and vice versa. You could see a situation where there's confusion about that. And the second thing is, it says, provided it's published within 7 days, the lien period runs from that date. Presumably, if it's not published within that period of time, it's the date of termination becomes the date that the lien period runs from. So there's a few wrinkles with the wording that we'll have to figure out how to deal with, but at least the concept is improved. The notice of termination goes out to the world within 7 days after it's been terminated, telling everybody, anybody working on the project has to understand that within 60 days you lose your lien rights unless you act. So that'll be a big improvement, provided everybody publishes their notices like they should. All right, so let's now talk about the consequences of that big change I mentioned between making holdback optional, the release of holdback rather at the end of the job, optional versus now mandatory.
So the point that we have on the slide actually kind of makes me giggle because of the amount lawyers and policymakers, we dwell on like one specific little word. But in this case, one specific little word made a really fundamental difference. So previously, the Act had said that holdback may be paid when lien rights expire. And when it said may, that meant that people would say, okay, well, we're not going to. So it became really optional. So the original change was to fix this so that the legislation actually said that holdback shall, which means it must, be paid when lien rights expire downstream. And so what was really critical about that change was to make holdback release mandatory. It was no longer optional. You couldn't just try to get out of it by relying on this one little word may. But the problem was that the changes to the Act didn't actually say when the payment was to be made following the 60-day lien expiry period, and it didn't say how. So even though the sentiment was good and on point, the functional how this was supposed to work wasn't fleshed out.
So the answer then becomes, first of all, let's specify when and how the holdback should be released, the holdback that now shall be released. Put some timeframes. We know with prompt payment over the last number of years, there's a whole regime. We're going to touch on a bit of the detail in a second, but there's a regime of owner pays contractor, contractors pays subs, and so on. Why don't we do the same with holdback? Why don't we have the owner pay the contractor the holdback within a period of time, and so on down to subcontractors, the various pieces of that larger holdback that's been retained from subcontractors down the pyramid. So a cascading release of holdback money seemed an obvious solution to the when, and the how should be by having a series of releases downstream. And that was one of the recommendations that I'd made in the report on your behalf, which Duncan Glayhold picked up and introduced. And it's now led to timing being introduced into the Act as of January 1st for the release of holdback. When the period has expired and it's time for the owner to pay the holdback, there's a 14-day period now under the statute that the owner's got to pay that holdback within 14 days, not a month, 2 months. I'll pay you your holdback 2 months from now. It's 2 weeks. Once the contractor gets the holdback from the owner within that 2-week period, there's a further 2 weeks to pay it down to all the subcontractors, and so on. So rather than 14,777, it became 14,14,14,14. Personally, I wish it were a little quicker downstream, but anyway, it's better than being stretched out. The only condition I should mention about that release is, of course, if somebody, and this is the case now anyway, makes sense, if somebody's filed a lien, until that lien gets dealt with, the holdback release process is stalled. You can't release holdback in the face of a lien. But once the lien's been vacated, security's been posted, then the flow of funds continues on. So we now have an actual when and how as part of the holdback release process, which will be great moving forward. So let's talk about annual. I had mentioned that annual and phased release of holdback had been introduced into the Construction Act originally. So let's talk about those topics now and what's happened with them. Yep, go ahead, Kathleen.
This is an interesting one, especially from my perspective, because I am a contract drafter. So previously, under the pre-2026 version of the Construction Act, annual and phase release of holdback was permitted, but only where it was agreed to in contract specifically, and under certain circumstances. And so, in other words, holdback could be released on an annual or phase basis if the owner and the contractor agreed to do so in contract. The problem with this framework, though, was that it left subcontractors and suppliers who, if you think about it, were often the ones who would benefit the most from this phased release or early release, especially trades who were doing work so early on in the project. They were left dependent on the discretion of the owner and the contractor, whether or not they agreed that this would be a function of their project, the project administration or the contract administration. And so because of this, it left those who would benefit the most not able to have guaranteed access to this. It didn't specify it also had other problems. This regime, it didn't specify when the mechanism for notice of a pending release was to be published or whether there was one to be published, and it didn't allow subcontractors the right to inform the contract terms. And so it really just wasn't. It was an option. It was available. But now we have a system where this has become mandatory.
And that's what became clear. So with phased release and annual release being both options, as you can imagine, not everybody adopted it, even where it would be beneficial. So what were the recommended changes? Well, the first was I pushed the idea that mandatory annual release be a function of long projects. If you have a 4 or 5 year project, it doesn't make any sense that the 10% holdback accumulate and accumulate and accumulate over the entire 5 years, and then this giant pot of money be released at the very end. When the trades along the way are finished their own work and have to wait 3 more years to get their holdback that's been retained from them on their contracts, that just seemed to make no sense in terms of the the effect on cash flow and choking off the flow of funds, they should get their money for the work they did earlier than the end of the job when they're long gone. So at least for longer contracts, we should have mandatory annual release. The second observation is there should be some notification process. As Kathleen said, if you're a subcontractor and holdback's about to be released because the owner and the contractor agreed that they do it every year or at the end of a phase, how do you know it's been released if there's no notification or heads up being given? So there's a couple of things. Well, what's happened? Two things important. Now, and we're going to dig into this in much more detail in a second. We've now moved in Ontario to mandatory annual release of holdback on all contracts that extend over a year. Not even 2 years or more, just even a year, a contract that runs a year and a half is subject to mandatory annual release, meaning at the end of the first year, the holdback will be released, and then the last 6 months of the project, the accumulated holdback will be released at the end of the job. We'll get into the mechanism in a second. So that's important. Related to that is the elimination of phased release as a possibility, but that's going to be transitioned over the next year. So the elimination of phased release, if you have it in a contract you're working on today, will happen a year from now into 2027, the anniversary date of the contract next year. So for 2026, if you have phased release currently, you can continue to have phased release for the rest of this year. The other important change is that publication of a notice of this release of holdback each year is going to be a requirement. So once again, Link to Build and DCN and OCN will be flooded with publication notices that the holdback is going to be released. So that will be something we're going to see. And let me explain graphically how this is going to work. So pulling everything I just said together. So we've got mandatory release of holdback on an annual basis and at the end of the job with substantial performance and the finishing holdback. And we've got the timing of release as well. That is spelled out, the 14-day release period, as I mentioned. So putting all this together, here's how it's going to look going forward. In the law is now in effect, and I'll explain the transition in a minute. So imagine a contract runs more than a year. At the first year anniversary date of the contract, the date the parties entered into the contract. As you can imagine, that'll be an interesting question. In some cases, when did the contract actually get entered into? But nevertheless, there'll be some fixed date, and this is going to be very important. And I recommend everybody on this call today that you make sure it's clear what the effective date of the contract is that you're entering into, because that is what governs this holdback release program I'm about to describe. So whatever the date was, fast forward a year, that's the anniversary date. Within 2 weeks of hitting that anniversary date, 14 days, the owner has to publish a notice that the owner intends to release the holdback that's accumulated up to that first year. Okay, that will be published, as I said, in Link to Build or wherever. Then there's a 60-day period. Now, in Bill 216, that 60-day period was considered to be a lien period, the 60-day lien period. Just like at the end of the job with substantial performance certification and the publication of that certificate, there's a 60-day period for people to file a lien. Okay, that's how Bill 216 a year ago contemplated this working. At the end of the lien period, the owner, assuming nobody liened, will have 14 days to release the holdback, just as I explained, to the contractor. That holdback is the holdback that accumulated in the first year of the project. The contractor gets that holdback and has 14 days to turn around and pay it to the subcontractors and they in turn downstream and so on to the point where all the holdback has been distributed that had accumulated at the end of the first year. Then you get to year 2, the same process again. I won't repeat it, but there'll be a notification, 2-week notification, wait period, the release of the holdback, and the release downstream. Okay. Eventually get to the end of the job where there's substantial performance. And this goes in the normal course. Certification of substantial performance will happen. The certificate gets published. There's a 60-day lien period. You wait to the end of that period and then release the money 14 days later, the holdback monies, and then it goes downstream. Okay, so that's the system. And that was set out in Bill 216 that was passed by the government a year ago. What people recognized, however, if you go back to that lien period box, is the way it was worded, everybody who had any claim over unresolved change orders or other monies owed had to file a lien during that period. Otherwise, they'd lose the right to lien ever for that early work. And people thought better of that and thought, well, hold on, that's just going to mean everybody will be running off filing liens in the middle of the project after the first year of the project, and it'll create kind of chaos on a project. Doesn't make a lot of sense. Why do we eliminate the lien rights? We don't eliminate lien rights in the optional version of annual release as it existed up until this point. There was no requirement that people lien, otherwise they lose their lien rights. So why would we do that here? So why don't we fix that, became the question. And that's what we spent the last year doing. From November 24 to November 25, we worked it all through. And Bill 60, which remember in my initial timeline was just past the end of November of 25, a month before Christmas, this past Christmas, that removed this feature of this being a lien period. And it's now instead, I'll call it a waiting period. You just wait. You sit and wait to see if anybody liens, but there's no requirement to lien, otherwise you'll lose your lien rights. So what that means is now it's just a waiting period, and what we've really got is a 74-day payment period. So you publish the notice, you wait 60 days and don't do anything, but then you have to pay the holdback somewhere between day 61 and day 74, the 14-day period for payment. So when you look at the act now, it says somewhere between the 60th day and the 74th day is when you make the payment as an owner of this holdback. But that's how we got to 74. It's really the 60 plus the 14. Okay, so that's where we sit now. So this process will repeat every year over the life of a long project until you get to the point where you're at the end of the project, at least substantial performance, and then there will be the release in the normal course that we're used to. I had mentioned that the act up until now had at the same time introduced a mandatory release of holdback, the shall that Kathleen talked about. There was a shall unless otherwise. So let's talk about section 27.1.
So section 27.1 is one of those ones where the act on first glance, when the original changes are made, it seemed to have made some really important strides, and in so many ways it did. And then as we get working with the act, we see there are some practical gaps. And this is one of those ones where there was a practical gap in the way this was working. So the original change under section 27.1, so under the pre-2026 version of the Construction Act, this section allowed owners to withhold all or part of the holdback if they issued a notice of non-payment of holdback in the prescribed form by the prescribed deadline. And so what this really meant, and some of you may have experienced the frustration of what this really meant, is that owners could essentially publish this notice and not give a reason for why they were not paying the holdback. And it essentially opened the door or created this ability to avoid paying the holdback, which essentially defeated the mandatory holdback release regime and the benefits that it was supposed to be giving stakeholders.
So the recommendation, therefore, was to deal with this in some way, at a minimum, force the owner to give reasons why they were not planning to release the holdback. And also there are some issues to do with commencing adjudication language that needed fixing if this was going to stick around. But as Kathleen just said, when you think about it, if holdback shall be released, to say holdback shall be released unless the owner doesn't want to release it, doesn't make a lot of sense. That puts us back to where we were back in 1983. All this progress kind of seems to be defeated. So recognizing that, in their wisdom, the legislature decided, you know what, let's just get rid of it altogether. So the notice of non-payment of holdback that an owner could deliver, that section, is now gone. That means the owner has no excuse anymore not to pay the holdback, not to release it within 14 days after the lien period has expired, provided there are no liens. They must pay it. And they can't say, oh yeah, but there's this problem, or yeah, there's these damages I've suffered, or this or this or this. They must pay it. They can't use the notification, at least, as an excuse, an exit door from their obligation to pay it. Now, are owners going to always pay it? Perhaps not. And so there's some other things we need to deal with about that. But at least they don't have the ready-made excuse not to pay it by giving simply a notice of non-payment. That's been repealed. You won't see section 27.1 in the current 2026 statute if you went online today. It's evaporated. So that's a big move forward for the benefit of the industry. So what does it mean for owners? It means that if they're concerned about, well, what if the work is deficient? What if I've suffered damages because there's been delays in the project, all the things owners might complain about. And I'm not saying the complaints are illegitimate. There may be genuine issues with the workmanship or something done by the contractor. The owner's going to have to figure out other ways of addressing that than using the holdback. The holdback now is the holdback, which is a fund of money for to protect unpaid subcontractors on a job. It's not a fund of money for the owner to protect against deficient work or other issues. So they'll have to address it through other security, performance bonds, whatever it is, but they can't now resort to the holdback. That's the big message. So we're almost at the end of the lien section. There's one more topic before we just break for a few questions.
So
Let's talk about section 30. Yep.
Yeah, so this one is another one where I kind of giggle at the extent to which we dwell on specific words, but the specific words really have a big impact. So under the pre-2026 version of the Construction Act, payers were prohibited from setting off against retained holdback or using that to fund, as Glenn just alluded to fund replacement work or to satisfy claims against a defaulting party. And so in this section, the word default is really critical because default isn't a defined term under the Act. And so if you think about what this word actually means, are they getting at termination? Are they trying to get at abandonment? It's really unclear, and we didn't know. And so this degree of ambiguity was a big problem with Section 30. And Section 30 as a whole, which Glenn will explain in more detail, really did seem to run contrary to or undermine this mandatory holdback release regime that we keep talking about how important that really is.
So at a minimum, what should be changed, we recommended, is the move away from the word default and stick to the termination or abandonment type language that has now been introduced in the Act, going back to 2017. So that's in fact what has happened. So now what the section says is, in relation to holdback, is that you cannot even look at that holdback in the case of a termination where you fired the contractor and gone on to hire a different contractor to finish the job. You may have extra expenses as an owner in those cases. The holdback you're holding against that terminated contractor can't be used for the completion cost until the lien period at least has passed. And then what happens remains a bit of an interesting open question. But as we'll say, there, and I mentioned this already, the trust obligations have been enhanced. The wording in the statute regarding project monies has now been amended to include reference to holdback as being expressly trust money. So what happens is that an owner, even though there might be the suggestion that in a case of a terminated contract, the holdback doesn't have to be released immediately to the terminated contract, it's got to be kept in trust and can't be used for other purposes until it's determined at the end of a court case or perhaps an adjudication how much of that money is available to be applied against the completion costs of that terminated contract. So it's just been a subtle shift, but away from default, which Kathleen mentioned was an undefined term, to more focus on a terminated contract. So with that, let's just see, Clive, if there's any questions before we move on to the next topic, next section.
Yeah, thank you, Glenn. That was very good. And certainly, I think a lot of questions regarding holdback. Prior to the changes, it was a very sticky point, especially when they may release it, and it was used for other purposes other than liens. The two questions that I have come in, and just before I do that, there's just so people aren't confused, you can send questions in at any time. We're addressing questions as we come to the end of each section. So I know there was a little confusion judging by the messages, but the messages, the questions I have now, does the annual holdback up to the anniversary date, is there any difference between that and the end of the project holdback? And does the annual include design professionals? And the second question was the same. Does substantial performance eliminate annual holdback provisions?
Yeah. So as I walk through, the holdback we're talking about initially is the one retained by the owner from the contractor throughout the job. And normally, before this newest change, that holdback would sit there in the hands of the owner, getting larger and larger as the work progresses and invoices are paid, and 10% is stuck in the holdback fund, at least notionally. And you get to the end of the job as substantial performance, and it gets published and it gets released. Now it gets released within 14 days. So now all that's been added, if you will, is that fund will keep getting fleshed out to back and paid out to the contractor and downstream each anniversary date. It doesn't affect substantial performance. There will be still holdback to be released at substantial performance. It's just that the amount of holdback at that point in time will be much less than it would have been otherwise, because much of it will have been released earlier in the contract or in the project each year, right? So if it's a 4.5 year project, when you get to the final release, it's only a half a year's worth of holdback, because the other 4 years worth of holdback will have been released by that point. So I hope that helps. The other question was the transition rule, and we'll get to the end of this presentation today and talk a little bit more about the transition. The simple answer at this point I'll give is that the annual release, being a mandatory requirement, kicks in next year, starting next year. there won't be any mandatory annual release during the 2026 year. It starts in 2027 onwards. So that means a contract from last year will have mandatory holdback release in 27, and a contract this year will have mandatory release in 27, because of course we're in 26. So the first year for a 26 contract will be in 27, but the first year for an older contract will also be in 27. So I hope that's clear. The second question I'll just quickly address, Clive, that I see has to do with these pre-construction services that we talked about, provided by architects or engineers that weren't subject to the 10% holdback. What does that mean? And the answer is nothing's different from today. The situation today is either they have lien rights or they don't, based on whether their design added value to the land or not. And if holdback was not retained from them, they were paid in full for their services, then it's up to the designer to prove that their design added value in order to support a lien claim against the property. The only difference today is if holdback was retained by the owner has to prove that it didn't add value. Otherwise, the assumption is it did. So it's just a subtle change in the owners of who has to prove what, depending on whether holdback was retained. So I don't know if there's any other questions.
No, I think that was it. And just to be clear, annual release of holdback only applies to projects that are longer than 2 years?
No, I had thought it made sense to introduce this kind of complicated regime, semi-complicated regime, for longer projects, more than 2 years. A project that's, a year and a month. And we still have substantial performance, of course, and everything else that applies. And also certification of a subcontract being complete is still available. So the excavator could still get the money. But no, they turned around in their drafting wisdom and made it apply to all projects that run longer than at least 1 year. Like a 6-month project is not going to have an annual release, obviously. Hasn't reached the 1 year mark. But anything that's 1 year or longer will be subject to this regime. It's not 2 years, it's 1 year.
Great, thanks.
Okay, well, let's move on to prompt payment. There's just a couple of things that got tweaked about that process that was introduced in 2019. And just by way of reminder, if you will, this is the process that requires payment by an owner to the contractor within 28 days of receiving the so-called proper invoice from the contractor. And then the owner has a choice of either staying quiet and paying within 28 days or speaking up and objecting to the amount of the invoice within 14 days by a notice, a form. And then that leads to a potential dispute over the amount of the invoice, and that could go to adjudication. We'll talk about that in a minute. But normally payments are monthly, perhaps it could be milestones. And then once the contractor receives payment, the contractor has 7 days to pay subcontractors and so on. Subs to sub, all the way down the chain is the 7-day period. And the other key thing is, from a contractor's perspective, if the contractor does not receive payment from the owner within time, the contractor has to alert the subcontractors downstream and promise them, undertake to them that the contractor is going to take the owner to adjudication to get that money. Otherwise, if you don't give that commitment, the contractor still has to pay the subs, even though the contractor hasn't received the money from the owner. So the bargain is you get to avoid having to pay subs money you haven't received, provided you chase the owner for the money. And that's really the deal that was struck, so to speak, that led to the prompt payment deferral of money while you undertake adjudication to deal with paid when paid clauses. So those were, the key changes. But starting with the proper invoice, the statute spelled out what the proper invoice was. And just before we get into it, this is the regime as it looked. I'm not going to spend a lot of time taking you through all the details. We've had this in place for the last, well, 6-7 years now. But this is the process of 14 days. The owner submits a proper invoice. And if you look at the bottom one, the owner pays within 28 days, but there could be a dispute farther downstream and various steps happen. But across the top is the ideal situation. The owner pays the contractor the full amount of the invoice in 28 days, and the contractor pays within 35 days and 42 days, and so on. The payments are made downstream. So there's various other scenarios, whether there's a notice of non-payment from the owner or a notice of non-payment from the contractor. But in each case, it's this sort of decision tree node of either do I pay or do I adjudicate if I'm not going to pay or if I'm not getting paid. And that's the way the prompt payment system has been working for the last number of years. We could get into more detail about how it works if people aren't familiar, but really the point here is to see what's been tweaked about this existing system. That's what we want to talk about. And it really turns primarily on the proper invoice. And maybe Kathleen, you can walk through us what the issues were with the proper invoice definition in the statute.
Yeah, so what you see on the screen right now is the proper invoice requirements as they existed prior to Jan 1, 2026. So Section 6.1 of the Act required that all of these items be included in a proper invoice for it to actually be considered a proper invoice, and parties could agree to, by way of contract, to require or have other items included. One of the things that we would see practically, because one thing that we do pretty often is review templates for proper invoices, is we would see these items that are highlighted missing or left off. And one of the biggest reasons is because they're so granular or were so granular. And so they're really specific, sometimes didn't make a lot of sense. And so they'd get left off inadvertently. And then that meant that a lot of stakeholders, contractors were submitting invoices that they thought were compliant that were not actually proper invoices. And so you had this problem where contractors were trying to comply with these requirements, but because of the really specific and granular nature of them, they weren't compliant. And that's really critical in this prompt payment system that Glenn touched on, in that the actual trigger for these rules, the cascading payment rules, the timelines, they're triggered by the submission of a proper invoice. And so by inadvertently leaving off some of these specific requirements, the prompt payment timeline regimes and requirements weren't triggered, and then you'd get to the end of the 28-day period and you'd had contractors going, well, why haven't I been paid? I submitted my invoice. But because no one had to tell them, and that's a point we'll get into a little bit later, but because there was no notification system, whether an invoice was improper or not, and these requirements were so specific, they weren't actually getting the benefit of this regime that was put in place.
So the wording, we didn't go through all the examples or instances in the existing act where the requirements were unclear and very often not met by the contractor. And as Kathleen said, if a contractor submits an invoice that doesn't meet the statutory requirements, it's then not a proper invoice. We'll call it an improper invoice in form, the formality of it. And that doesn't start prompt payment at all. So wouldn't we want better, clearer requirements set out in the statute of what makes a proper invoice that people would actually comply with? Otherwise, the prompt payment system kind of falls apart. And one of the examples of the requirements of a proper invoice was the requirement that you name the person, have on the invoice the name of the person that the payment should be remitted to. The name of the actual person, in the accounts receivable department or whatever, which would make most invoices, many of you would provide to owner clients invalid, improper, because it's missing the name of, paying the name of the person in the accounting department that payment should be made. But that's what the statute said. So that didn't make a lot of sense. So let's fix it up. The good news is they heard us, and the government has now changed the requirements for what constitutes a proper invoice to make it more likely that what gets submitted to owners by contractors meets the requirements. And these are the underlining on this slide shows what the changes are that are made to the 2026 version of the definition of proper invoice. And some of those things that were creating problems have now been addressed. So for example, if you look at number 6, rather than name the person, it now says if payments to be sent to an office or a department, its name. So if you say on your invoice, the accounts receivable department at this address and number, that's fine. You don't have to name a person anymore because that, didn't make a lot of sense. The other thing to just point out, though, that's important, people have noticed, and that this is that they've added 6.1, which is any other information that's necessary for the proper functioning of the owner's accounts payable system that the owner reasonably requests. So you have to pay attention to that. If the owner says, when you submit an invoice to me, for my system, I need you to include this code or submit it through this portal or whatever. Those are the kinds of things that the statute contemplates are, provided they're reasonable, are requests an owner can make to facilitate payment of the proper invoice. So look for that. I mean, Kathleen and I have seen practices develop with proper invoices and their form, where the form itself may be an attachment, an exhibit to the contract, for example. This is the type of form. Or at least the owner says, this is the format of an invoice that I need from you. And that's presented early on in the project before any payments are submitted, and talk through it, the kickoff meeting, for example, walking through, okay, is there anything about this invoice that, I need to understand that is special that you need from me? Because those are the kinds of things you want to get straight and clear before you start submitting invoices. So the form of invoice is now something that has been at least recognized as needing some enhancement, the form of proper invoice as it's described in the statute, and we've got that. The other thing, though, Kathleen, you mentioned, and that is the owner's responsibility in terms of getting an invoice.
Yeah, so in terms of this one's interesting when you think about it from a project administration perspective, because you have all of these requirements that you have to include in your invoice and they have to be submitted in accordance with the Act. But when the job's actually moving and you're actually submitting invoices and you're submitting them quickly, and you're trying to complete all your work at the same time, and something is missed, there was no system before, no requirement before that if something was missed on your invoice, that the owner had to notify you that the invoice was improper. And if you think about that practically in the context of like when you folks are trying to actually administer a contract and a project, this is really problematic because you'd submit an invoice thinking it was compliant, and then nothing would happen. You wouldn't be notified at all. There was no obligation to be notified if something was wrong or if the invoice was improper and therefore not compliant with the Act and therefore not triggering the prompt payment regime.
So how would you solve that? Was the question we were facing. The fact that the owner could sit in the weeds quietly in the face of an invoice that they considered to be improper, but there's no obligation to speak up. Well, the obvious answer is require them to speak up. And that's what I recommended happen. I said speak up very quickly within 3 days of receiving the invoice, whether there's a problem with the invoice, because I didn't want this to drag on and become a dispute in and of itself, the form of invoice, because we're not talking, just to be clear, about the amount of the invoice. That's not what we mean by an improper invoice. The amount may be considered improper, an invoice for $1 billion, but we're just talking about the form. The amount is something that can be objected to by day 14 through the notice of non-payment of invoice. We're talking about basically, how do you notify the contractor about an improper invoice in terms of form? So the recommendation was to require an owner to speak up within a short period of time that there's some problem with what's been submitted as the invoice. Otherwise, you're stuck with it as an owner. You have to pay it within 28 days. So speak up or shut up is really the rule. It's deemed to be proper if no objections made. So what does the legislature do? It agrees to that, except they've given the owner a little more time, 7 days. So now the rule from this point forward, starting on January 1st, 2026, is that if the owner receives an invoice and doesn't object to the form of it, it's deemed to be proper, even if it doesn't have, for example, the name of the payables department or the receivables in terms of the contractor's payment department. Even if it's missing that or any of the other pieces of information we saw are required by statute. If the owner doesn't say anything, the owner has to pay it anyway. That's the new rule going forward. Now, if the owner does speak up within 7 days and say, you're missing this information, you forgot this statutory declaration I require under the contract, you forgot this, you didn't name this, it doesn't have the date properly, it doesn't have my coding, well, then there is this requirement to speak up and the contractor has to correct it. And then hopefully the owner agrees that the corrected invoice then stands as of the date it was submitted. If the owner says, now I've got the proper invoice, the clock starts now, at least you know you've got 28 days before you can expect payment from the corrected invoice. So it's going to be important for contractors who receive some objection notice from an owner to correct the invoice as quickly as possible, because likely that's when this 28-day clock will start. So that's a big improvement, though, that basically if a contractor handed in a napkin with a number on it, the owner doesn't speak up, the owner has to pay that amount within 28 days. Otherwise, they're offside the prompt payment rules. So let's just pause there and see if there's any questions arising from the prompt payment section, Clive.
I think there was just the one, and I think we've got it answered. It was in regards to what I was asking about the 1 and 2 years that you answered. So if you have a project that's a year and a half or a year and 3 months, at the 1 year anniversary, you still got to release the holdback for that 1 year. And then when 3 months later, the project's done, you do substantial performance, you publish, and you got to release the holdback for those 3 months or whatever the time period.
Yep. So,
so that was
that's good. I do see there's a question about invoices as well, though, that we were just talking about, that says they're often dated and submitted before the last date of the month being billed. Is this acceptable? And what date is the invoice date? So the important date is actually not the date put at the top of the invoice, but the date it's received by the owner. That's what triggers prompt payment. If you read the statute, it's the date the owner receives the invoice, not the date of the invoice. So if I sent you, Clive, an invoice today that carries work through to the end of the month, you can see the problem. The invoice from the owner's side should cover the work that's been done, not prospective work. And so it's likely the owner will end up objecting to that invoice because it's over invoiced in the sense the work hasn't been performed that you're expecting payment of. But so they may cut it back. But the idea is that the owner will pay the amount that's appropriate for the work that's been performed that's covered by the invoice they receive. But it's the receipt date that's the relevant date. So what that means in practice, and many of you may have seen this be introduced over the last well, 6-7 years we've had prompt payment. And that is a requirement in contracts that the contractor produce what I'll call a draft invoice prior to the month end of what's being proposed to be billed for that month, and sit down with the consultant or payment certifier and say, this is what I'm planning to bill. And the consultant will look at it and say, oh, that seems fair. If that were invoiced the next day, there would be no objection made. On the other hand, the discussion may say, are you kidding me? You haven't completed anywhere near that amount of work you're trying to bill for. If you put that in, I'll end up cutting it back, just so you know. Now, approval of the payment certifier cannot be a condition of invoicing. The Act is clear on that. It's just that whether you get a dispute or not is going to be something you'd like to know sooner rather than later as a contractor when you submit your invoice. So that's been a practice that's developed to try and address some of these requirements, because it's a very short time frame we're talking about. You know, a 2-week turnaround time from invoicing to response, whether it's a problem or not. And so there's been this practice developed of a kind of a trial or a beta version, if you will, of the invoice being presented first. So I hope that helps.
There's a couple more. I'm getting questions from 2 different sources here, so
Yeah, I understand.
I got to switch back again here. I believe we discussed fairly clearly that regarding services that are provided, if they provide value and there's a holdback, then they're subject to these rules. So designers and architects and so on. And there was, go back to this one. Oh, a general question. Has prompt payment generally worked well as expected, aside from the invoice form itself?
It's a great question. I think many of the people on this call will have their own experiences. They might be in a better position to share than certainly Kathleen or myself about how it's worked. I will say that at least in the public sector, the stories, the anecdotes that we hear is that it has significantly improved payment, because municipalities, other public owners realize the law requires them to make the payments, and they've improved their payment systems, internal systems, electronic payment mechanisms with limited approvals, such that it is working more smoothly. I will say, there, to the extent there's been complaints about all of this being of no value in the private sector, and payments are still taking long and so on, I think that's not a function of the way the law is laid out. It's a function of enforcing it, and the reluctance of contractors to hold owners, for example, who are late in paying, slow in paying, to account. The law requires them to pay. The fact within 28 days, the fact that they're not paying within 28 days, if that's the case, you can go to adjudication and insist that they do. But the moment you do that, if the owner is going to say, well, if you're going to do that, then, I'm not going to ever work with you again, kind of thing. That's an industry issue. That's not a legislative issue. The system is there to benefit the industry, but it requires people to buy in to it and honor the system and pay in accordance with these timeframes. And if they don't, but nobody holds it, those parties that are owners that are breaching the rules to account, well, then you can't complain about the system. I think that would be my practical answer.
Yeah, we heard the same thing prior to my retirement and my involvement in the industry for a few years after that. Generally, that's what we heard from members of the OGCA, that it was driving better behavior. And that you're right, the private sector was paying, but it is up to the contractors in that to hold the owners accountable. If they don't want to hold them accountable, there's not much we can do. We've got the law on our side, but we do have to hold them accountable. There was a question which I kind of I wouldn't, the question is, if an engineer takes longer than required to prepare the invoice amount, and I don't know why we're picking on engineers, but could be architects, subtrades, and everybody else, should the contract invoice date be extended or not?
So that's a very practical concern, I'll say. But that hold on, the engineer, whoever the payment certifier is, architect, engineer, or other consultant, is taking too long to let me, the owner, know whether there's an issue with this invoice. I, owner, have 2 weeks to tell the contractor there's a problem, and I have to give them an actual form 1.1, the notice of non-payment, within that period of time if there is a problem and I'm not going to pay the amount of the invoice in full. Otherwise, the law requires me to pay the invoice in full by day 28. Okay. Well, how do I know how much to pay? I need to turn to my payment certifier. And if they're late in getting back to me, unfortunately, there's no statutory excuse that gets created. What happens is the owner has to pay in day 28 the amount. Now, the next time, if they get caught up, they may short pay on the next invoice to kind of rebalance perhaps, but they're stuck paying, according to strict wording of the prompt payment process, paying the full amount of that invoice that was never objected to within time. And if that matter were taken to adjudication, which is the next topic we're going to talk about, I think the owner would lose. So what that means is, first of all, owners have to hold their payment certifiers to the standard of, you got to turn, you can't just sit on this. You got to turn around because I have to pay this contractor monies I maybe shouldn't have to pay. If you got around to telling me in a timely way that that's so you've got to process more quickly if that's a problem. The second thing is, I already mentioned the practice of having a pre-look at what the invoice is going to be, gets the consultant, the payment certifier, focused in on where there could be a problem, what's about to come in the door is the proper invoice. And that may accelerate their ability to properly inform the owner about objecting or not objecting. Maybe the invoice is fine, but that's why you need those discussions as part of this approval process. But yeah, there's no excuse in the statute. The date of the invoice that was submitted is the date the clock starts on the owner's obligation to either object or pay. So that's simple.
I'll just note, we, like, on a practical basis, we've seen that going into consulting agreements much more frequently, like baking into the actual contract, the window within which the consultant or payment certifier needs to notify the owner if the invoice is non-compliant. So as a practical drafting point, we've seen that going into the actual consulting agreements.
So consultants have to understand they have that exposure or that responsibility contractually to an owner to do their work in a timely way. They can't say, well, sorry, it was Christmas holidays and we didn't have the people around, and because that puts the owner at risk of overpaying potentially the contractor. And the owner is going to be very unhappy, of course, about that and look to the consultant to answer for that kind of thing. So the consultant has to appreciate there is this extra responsibility, which they have to take on, but, charge for and, recognize it's a risk that they've got under these consulting contracts that include payment certification.
Okay.
Well, with that, then let's turn to the next topic, adjudication. And there were a number of changes about this whole new process that were made, changes that were made to it that are all intended to make the system work better. Now, there will be people in this call today that probably likely have not gone through an adjudication and may know the term, but still really aren't familiar with the process. So I'm just going to take a minute walking through what we're talking about when we say adjudication. So this is the process that was introduced in 2019. So we've had it in place for, about 6 years or so, or less, that deals with disputes going on a project in real time. So rather than everybody go through the project and there's unresolved change orders and problems, and you get to the end and then everybody sues each other and you go off to court for several years, or file a lien claim, or go to arbitration, all of which remains possible. This is another process to resolve disputes way more quickly in the middle of the project, potentially. And so the intention is that this process could deal with unresolved change orders, disputed change orders, or other extras, payment that should have been made, prompt payment that should have been made, wasn't made promptly, holdback, release issues, all this kind of stuff. The decisions on all these types of disputes are being made by adjudicators, not arbitrators or judges, adjudicators, who are a group of people who have applied to become approved adjudicators, governed by this association or group, organization rather, in Ontario, whose acronym is ODAC. And you can go to the ODAC website and read all about adjudication. There's lots and lots of reference materials there. The intention is that disputes be resolved quickly. And by quickly, we're talking about in the span of weeks, not months or years. That's the intention. And these decisions, they're called determinations. The important thing is they're described as interim binding. Now, binding means the parties are stuck with the result. The interim means that down the road, if you went to court or arbitration, that decision, result coming out of the court or arbitration, may be a different result than what you got in the initial adjudication. So it's not that you have the right to appeal the result of the adjudication, but what you can do is go to court and get a judge to decide differently if you're unhappy with the initial adjudication. You still have to live with that decision up until somebody else decides differently. That's the way to look at it. But the whole idea of having interim decisions is it gets money flowing more quickly. And the way to think about it is, imagine, it's a trite example, but a baseball game where you didn't have an umpire behind home plate making balls and strikes, calls. How would you operate the game, right? That was a strike. No, it wasn't. Yes, it was. Like, the game would grind to a halt. You need somebody calling balls and strikes while the game's going, with the idea that the ultimate outcome of the game may be redecided later after the fact, but at least you've got somebody making decisions in real time. So what does the process look like? I'm just going to quickly run through this for everybody's benefit, catch you up. It starts with a notice of adjudication being issued by one of the parties, either to a contractor or subcontract, the owner, the contractor, subcontractors, who has an issue, a dispute. Then it leads to the appointment of an adjudicator, depending on timing, whether there's agreement or not. And then there's a process of handing the documents that to the adjudicator that are the subject of the dispute. It could be the documents to do with the proposed change order, for example, that the owner is disagreeing with. And then there's a process. Usually there's a case conference initiated by the adjudicator at the outset to set the stage, the amount of time, and when paperwork is going to be exchanged. And then the concept is that the decision emerges 30 days after the fact, after the start of the process. So we're talking about weeks, not, as I said, not months. And then at the end of that process, you get a determination. Now, that 30 days may be extended by agreement. The complexity of the matter means it's got to take longer. That's fine, but at least the base case is 30 days. So the whole process is intended to take less than 45 days. And then the result that comes out the back end, there's one of three things that happen. Either payment is made. It used to say 10 days, but as of January, it now says 15 days. Payment is to be made. And then once payment is made, it's paid downstream to subs and sub-subs and so on. Alternatively, there's something that's horribly wrong with the process, according to one of the parties, and you do not want to pay the determination because it's, for example, the type of dispute that's not something an adjudicator could deal with, or it was brought way too late in the process, or there's some objection you have to the adjudication process. You can seek to have that set aside. I see it says 30 days. I think it's now 35 days. That should be changed, sorry. But what's clear is from the court decisions in this area that the price of admission to get the court to hear that case is usually paying the amount of the disputed determination either into court or to the other party. You've got to put the stake up in order to object to it. And if there's just simply no payment of the amount at all, so if the contractor's entitled to be paid a certain amount of money and the owner just simply doesn't pay it within 15 days, then there's a bunch of remedies. You get interest on it. You could file a lien, of course, for it. You can turn it into a court judgment, just like a court case would give you. And most importantly, you can down tool on the project, stop work. And the statute makes the owner liable for the costs of suspending the work, and also if you're off-site, remobilizing to get back on site once they pay the amount of the determination. So there's a bunch of tools available in the adjudication process to enforce the judgment, the determination that you get out of an adjudication process. So that's the process as it's gone on for the last number of years. But we've identified a bunch of issues with that process, tweaks that are required to be made to the process over the last 5-6 years. And that's what has been addressed in Bill 216 and 60 that have now come into force. So I'll just walk through this, Kathleen, quickly, just to move through these. The first is the description of what you can take to adjudication was a little unclear whether it included other things or not. Some disputes about what you could adjudicate. That was something that needed to be addressed, and clarification should be made to the language. Those changes have now been made. One of the things is they took the list of things and put it in the regulations rather than in the act. And they've added some clarification around the types of things you can adjudicate or an adjudicator can consider. I'm not going to dwell on all this stuff because these are the kinds of things when you get into it, you'll need assistance with, in all likelihood, and you can follow the process. I'm just giving you the high level changes. So one change was the scope of work, or scope of adjudication rather, that an adjudicator can consider. A really interesting change, though, that will make a significant difference to everybody's lives here in terms of adjudication, is that the statute as written had a cutoff date for adjudication being the date the contract is complete. Once you're finished the project, adjudication was no longer available for disputes. Well, when you think about it, it's at the end of the project. You finish the project, but you're still fighting over change orders or holdback release and so on. Makes sense to have adjudication available for longer than just the end of the project. The other problem is if the contractor was terminated partway through the project, could the parties go to adjudication after the termination or not? That wasn't specified in the act one way or the other. There was just no rule at all about post-termination or abandonment. So what do? Well, the recommendation made is that for post-termination and post-completion, you add 90 days, 3 more months to the availability of adjudication, so that if you have a dispute at the end of the job over the value of some additional work that was done during the course of the job, a change order dispute, you can go to adjudication over that and get an adjudicator's decision. And that was the recommendation. And in fact, that's been adopted by the government. It's in new legislation as of January 1st. So you now have 3 months, 90 days beyond the completion of the project or beyond the termination of the contract to go to adjudication, which is a big improvement. The same issue cropped up with subcontracts. The problem is it talked about subcontract completion being a cutoff date if you have a fight between a general contractor and a subcontractor, for example. But there's even no definition in the Act for what a subcontract being complete meant. So what's been changed? We needed to fix that. And in fact, that's what's happened. Now it's 90 days after the subcontractor has left the site, finished up the work, or is otherwise finished being involved in the project. You've got 90 days to deal with unresolved subcontract changes, for example, or other types of claims a subcontractor might have to go to adjudication, which up to now didn't exist. So that'll be a big improvement for subcontractors, where there's some dispute over some, mechanical electric extra and the value of it, and the contractor is not agreeing to pay. So that'll help. Another thing that wasn't in the statute clearly is the ability to say to an adjudicator, look, you have no power to decide anything because this contract has been complete for 6 months, for example. And as I said, whether it was the date of completion or now completion plus 90 days, it means you can't go to adjudication 180 days after completion. But what if somebody tried it anyway? Well, what do? Well, you now have the ability to what's called challenge the jurisdiction, the power of the adjudicator to deal with it. But you have to do so right up front. And there's a whole process in the statute, the regulations for doing so, which is very helpful. So now an adjudicator will be asked in those special circumstances to decide on the spot, can I decide this case or not? Now, the adjudicator may decide that the adjudicator can deal with the dispute and will go on and deal with it. And then you can further challenge that perhaps later, but at least there's a process of challenging it at the other side. Now, there's a bunch of other changes we can talk about. First of all, there was remember I mentioned that if you didn't think the adjudicator should have decided the case the way they did, you can't appeal the result, but you can appeal, in a sense, you can have a judge review the process that the adjudicator ran, because it might be possible the adjudicator didn't follow the rules under the statute or allowed certain things to happen that should never have happened. So you can go to court and challenge the result by virtue of the process. So for example, and there's been cases like this, if an adjudicator didn't allow one of the two parties to respond to an allegation being made by the other party, then that's not a fair process. And the unhappy losing party was successfully able to go to court and have that decision overturned, set aside, because the process that the adjudicator ran wasn't a fair process. That's the kind of thing that a judicial review allows. One of the problems is the grounds for judicial review contained a phrase that made no sense. You could challenge the adjudication if the contract had ceased to exist. I don't think anybody here, including me, could explain what does that mean in this context. Of course, the contract doesn't cease to exist. The contract to build the building, the construction contract, is a construction contract. It doesn't evaporate. So that had no meaning. So they've changed that, which is good. The other thing is they've enhanced the ability of the adjudicator to penalize a party who's being a jerk, who's not cooperating, who's stretching out the adjudication unnecessarily, who's just being very difficult. And also, in fact, being difficult potentially on the project itself, being very unreasonable. There's the ability to penalize that party in the hands of the adjudicator, recognizing that normally parties split the cost of the adjudication 50-50. They each share in the cost, but the adjudicator must decide one of the two parties is being really silly about this thing and causing all sorts of grief and frustration and heartache. So I'm going to order that one party bear the whole cost of the adjudication because it's otherwise frivolous and vexatious conduct. So that's something that's been introduced. One of the biggest changes in terms of adjudication, at least in the world of adjudicators, is the creation of a whole new category of adjudicators. Used to be just the one category of officially licensed adjudicators under ODAC. Now there's a new category called private adjudicators. And those are, I think, intended to be senior retired construction industry professionals who want to sit as adjudicators, but only want to take on big complex cases that fall outside the day-to-day types of cases that the ODAC adjudicators, now going to be called registry adjudicators because they're on the register of adjudicators. It's a different category, as I say, intended for the more complex projects. And it's actually specified that those private adjudicators are going to charge $1,000 an hour to deal with those cases. But if you're dealing with a $40 million dispute, which is possible in adjudication, you may not want necessarily your adjudicator to be somebody who's doing their first adjudication who just did the training last week and just starting out. You want somebody who's senior and experienced. So that the door has been opened to private adjudicators, which will be interesting to see how that plays out. And the final thing I'll mention, there's a bunch of other tweaks we don't need to get into, but the final thing I'll mention is that adjudication decisions up to now have been opaque. You have no idea what's going on unless you're one of the parties involved in an adjudication. You obviously know the result in your own adjudication that the adjudicator's written up in the reasons, but you don't know what else is going on other adjudications. Unlike court cases, there's no database of decisions that you can go research and look up what kinds of outcomes, decisions are being made in these kinds of circumstances about these kind of things. There's no database about any of this. It's all been private up to now. So what we're going to end up having is a database of adjudication decisions starting next year, where in all likelihood it'll be generic. You won't know who the parties are, but at least you'll be able to read what a particular adjudicator decided on a set of facts. And that is not a precedent. It's not like the adjudicator can say, well, because adjudicator Smith decided this, I'm bound to decide the same thing. It's more a case for the public to understand, if I'm going to adjudication, these are the kinds of outcomes I may run into. And they've had this kind of system in other tribunals, other types of settings. I was an arbitrator for a number of years on a Terion arbitration panel, and those decisions were publicly available on the Terion website, but they were genericized, anonymized, if you will, where the names were all removed. It's more about the content of the nature of the dispute and the decision than who it was. So those are the changes to the adjudication process that are the key changes. I think what we're going to find is they're all intended to help the process become better, help adjudicators make better decisions because they'll see what others are doing. There'll be more consistency, more predictability of outcome, hopefully. There'll be more ability to go to adjudication over slightly broader, at least, range of types of disputes. And at least the rules around adjudication are clearer. The other thing I didn't mention is that there's more ability to consolidate disputes relating to a project between the owner and the contractor and subcontractors collectively, it can be all addressed in front of one adjudicator rather than a bunch of separate adjudications, which may lead to results that are inconsistent with each other. I mean, just imagine a contractor takes a sub to adjudication over some dispute with mechanical work, but the owner takes the contractor to dispute about the same mechanical work with a different adjudicator. You end up with different results potentially. That can all be consolidated. So that's another big change. So Clive, maybe we could just pause and see if there's any other questions about adjudication and the process more generally that anybody has.
The one question I think you've answered, and that's that the database will be genericized, and
yes,
yeah, so that answers that. I think one of the, it's not so much a question, but a fact of what's happened with adjudication when we brought it in. It first off, we didn't get the tsunami of adjudications that people feared, because it did drive good behavior and people didn't want to go to adjudication. The other problem was a lot of people weren't educated on how adjudication works and didn't want to use it. And the third problem that has become even more relevant today, and I've had several clients bring this to me, and we can't provide the actual data because the people providing the information are afraid of being blacklisted if they come forward. And it's a problem, one that I actually discussed with Duncan, and it also has to do with the payment terms and so on, is there is no penalties in this act to stop bad players. The small and mid-sized contractors do not have the power to take on massive corporations when they build into their contracts, and I have copies of those contracts, for instance, saying that to benefit the better organization of our company, we will be paying in 90 days. And if you want to get paid earlier, we're happy to provide you a low interest loan with an American bank. That's in an actual contract that was put out here in Ontario. The same is true with clauses that I've seen. Municipalities and public sector tried it in the beginning, trying to put clauses in that if you arbitrated or you went to adjudication, that it fell under their dispute clause, in which case you couldn't bid on any further work. So I don't see, and as I say, I did discuss this with Duncan and he didn't realize this was going on, and I sent him copies of the contracts with the language, which astounded him. But was this ever discussed, and how do we find a way to address this? I mean, adjudication works, but now you've got the problem that if you adjudicate, you're not going to be bidding for some time. And maybe the clause includes a provision that if we lose the adjudication to you, you're banned for a year.
Yep.
And
So
I've seen that. So
the chilling effect of pursuing adjudication, the act of pursuing adjudication, the chilling effect of I'll call it the debarment clause is the technical term of what you're talking about, where a public owner, typically a public owner, but not necessarily a public owner, it could be a private owner, says, if you take me to adjudication, you're off our bidders list, what you're talking about. That the chilling effect of that kind of practice, really, when you take a step back, is completely offensive, because this is a statutory process that, because of particularly the inner workings of prompt payment, as I explained earlier, requiring a contractor to go to adjudication when the owner hasn't paid the contractor for whatever reason, in order to avoid having to pay subcontractors money that they have not received yet from the owner. The commitment, as I was explaining, is to go to adjudication. Well, the moment you have to go to adjudication in those circumstances, and then face the owner saying, well, you took me to adjudication, you don't get to work anymore, is crazy. So that was raised, you're absolutely right to answer your question, Clive, with Duncan. It's mentioned in his report as a thing. The problem is he felt the the solution to that, which is more a pick on municipalities, a public sector or municipality problem to address for the government, rather than a Construction Act problem, right? The practice of a municipality, putting you on the blacklist for bidders is something that is not the Construction Act issue. It's, the Municipal Act or whatever appropriate other forum, I think applies. It's really subject to that. So as a result, I think it's still on the radar. It was mentioned. I think Duncan felt it's not really part of his mandate when you're trying to fix the act itself, but it's a real thing that needs to be addressed. Now, when confronted, I've seen some owners say, no, adjudication itself is not part of what we're talking about. When we're saying if you take us to court, et cetera, we understand that. But I've seen other procurement policies specifically reference adjudication among arbitration and court and other things as an example of you do that, you're off our list. So I'm not sure how a statutory payment process can function if the remedy for dishonoring that process itself leads to being blacklisted, right? It really needs to be addressed. So I'm with you, Clive. That's something that I think still remains on the radar that needs to be subject of further lobbying and attention to prevent that from happening. You can't have a system in place about payment on contracts where when you go to enforce the non-payment on those contracts, it means you can't work anymore. That's the big stick.
Yeah, I agree. I think it is another issue that the associations are going to have to take on and coalesce around and put as much effort into fixing as it did this, or there's a lot of people still getting hurt. But so thank you.
One last thing about the genericization of decisions that just came up in the previous question. In the regulations, there is a section that addresses the establishment of this database. And the way it's going to work, it's all spelled out in the regulation, anybody can read it, is that at the time the decision is made by the adjudicator, ODAC, the authority that administers this whole process, will ask the parties, do you want this genericized, and what parts of it do you want blacked out, if you will? And then the parties will indicate what that is, and then they'll honor that, is really what it comes down to. So it'll be, the parties may say, don't put the amount, don't put the parties' names, whatever it is. But of course, we don't want to go so far that the decision is, just 10 blacked out pages. That doesn't do anybody any good. In light of current things going on, you can picture in your mind's eye, I'm sure, what I'm talking about. It really doesn't share any information if it's all blacked out. But the idea is there will be the ability to genericize these decisions on the part of the parties to protect their interests, but it will appear in a database, which is helpful. So let's move on to the final section we wanted to cover, which is a few other miscellaneous changes, and finally the transition rules, which we've touched on from time to time today, but it's worth clarifying. So the key changes, in addition to the lien reform, prompt payment new regime, and the adjudication regime, which are the big three topics we talked about, there were a bunch of other little changes that were made, or not so little in some cases, but other miscellaneous changes that were made at the time the Construction Act was created, which themselves have had to be tweaked through the latest update starting Jan 1st of 26. One of the big changes was the bonding on public projects. I'll just say in passing, there were some issues raised about the form of bond that have now been addressed or will be addressed. The original form of bond that was part of the regulations for these public projects. There was some language around how lien forms and other documents could be fixed if there's some error in them. There was a new written notice of lien form, which is the form you give when you, as a subcontractor, for example, want to let the owner know that you're owed money by the contractor, the general contractor. There was the ability to publish notices electronically on websites like Link to Build. That was introduced back in 2018. And then transition rules back in 2018 between the old act, the lien reform, and the prompt payment and adjudication reform. So we're going to just pick on a few of these, not all of them, just to show you what's been changed starting January of this year. Why don't, Kathleen, you start with the written notice of lien?
Sure. So the written notice of lien was introduced. A lot of these changes, if you've noticed a pattern, were introduced to kind of standardize the process of what different concepts, or standardize the process related to concepts introduced through various amendments. And one of those was with the written notice of lien Form 1. So it was introduced to standardize the notice process, the notification process. Form 1 had to be sent. Form 1 had to be sent, but then practically this meant that there was a duplication of process, especially when there was also a lien registered. So we had this duplication of process, even though the intention was good, the standardization actually created a duplicating effect.
So, and as Kathleen just said, if I'm a lien claimant and I register a lien against the project, I now have a registered form of lien. But then there's this other form on a written notice of lien, and the act required that I give the written notice of lien, even though I haven't the actual lien as well. So it made sense, and my recommendation was to use the registered lien as an alternative to the written notice of lien. You use one or the other, but you don't have to use both. That didn't make a lot of sense. And that was the recommendation. And the good news is they heard and fixed it. So now, if you registered a lien, you can use that as your written notice of lien. Now, the written notice of lien, remember, it's been around since the act in 1983. If an owner receives one from a subcontractor, for example, the owner has to deduct from further payments to the contractor the amount set out in that notice. So that's what the form had, an amount, and that's what had to be deducted from further payments until the written notice of lien is cleared in some way. Well, now the claim for lien can also be used as that same form or for the same purpose. Unfortunately, another problem with this legislation was that the form itself has to be officially served on the owner in a formal way, almost like you're suing the owner, a statement of claim type of service, which didn't make a lot of sense. And we advocated that it be removed, that formal notice, formal service of the notice, and yet it didn't get fixed and still remains today in the act. So there's a formality to this step, but that's something that you'll have to get advice on. But nevertheless, at least it's somewhat simplified in terms of the form itself. Maybe I'll just run through the list of some other changes. I mentioned that there were challenges with understanding the language of some of these provisions that describe how forms that contain errors could be fixed or overlooked. The wording's been corrected. Won't take time now to say how, but at least they fixed the act, which is good. One of the problems is when they talked about electronic publication of forms can be allowed, it didn't say by whom. It was possible that dozens of websites could step up and start saying, hey, we'll publish your notice. And those people looking for these notices wouldn't even begin to know where to go looking. Now what's happened is the regulations have officially authorized, linked to build, which is great for everybody on this call. Of course, the Daily Commercial News and the Ontario Construction News as the 3 official authorized sites to accept publications of all these different notices that we've been talking about. So that was a good improvement, at least in terms of getting clarity. So if you're looking for where a notice was published, you only have to look in 1 of 3, or look in 3 places rather than 13 or 30 places. And then finally, the last topic is the transition rules. And this is a very interesting one. Maybe you can kick us off, Kathleen, if you want, and then we'll get into a bit of the details and where it goes from here.
Yeah, I'll be brief. Luckily, Glenn is one of the most knowledgeable people surrounding these issues, so I'll leave most of this description to him. But essentially, under the various amendments that have come into force over the last number of years, we're in a situation where we have been in a situation where there's been uncertainty in terms of which rules apply to a specific contract. And a specific project, and what rules apply to the project has until now been determined by the date of a specific contract. Uncertainty around which contract governs the legal regime that's applicable was interpreted by the courts, who've said that it is the first contract to do with the improvement is the contract that determines which regime applies. That in and of itself is problematic, which Glenn will explain, but we have a new set of transition rules that are also applicable to the amendments that come into force Jan 1.
So the issue being, as Kathleen said, if we have pre-2018 law, 2018 to 2019 law, October 1st, 2019 is prompt payment adjudication coming in from then till now, and now new laws, the changes we've talked about today, onwards, how do you figure out on any given project which of those legal regimes applies? So they created some rules around that, but unfortunately the way it was worded and eventually got interpreted by the court, it became the case that the earliest contract for any service of any kind that relates to a project, even a project years in the future, determines the law that relates to that future project. So if you hire an engineer in 2015, 10 years ago, over 10 years ago, to design a project that's under construction today, started construction, the law from 10 years ago, 2015, applies to the project today. That's how it was interpreted. As you can imagine, that was not what anybody really envisioned or intended, but it's the way it got worded and interpreted. So it was kind of a mess because all the improvements of prompt payment and cash flow and adjudication of disputes got lost on projects that were engineered earlier than those systems came into effect. Even though the construction contract got potentially tendered out and entered into in 2020 or 21. The engineering took place prior, and that's what decided which law applies. So I certainly recommended that process gets scrapped and we come up with a better process for at least the new changes. And in fact, I'm pleased to say that's what's happened. And with a couple of exceptions we'll talk about, it means all of these changes we're talking about are in effect today. Whether it's a contract you're in the middle of or just starting out or finishing off for the next few months, the new rules we talked about apply today. And of course, for new contracts and subcontracts that get let into the future. There's no transition for many of the provisions we're talking about. There is transition for some of them, a handful of them, and we've touched on that. One of them is the holdback release on a mandatory basis each year. That's been deferred till next year, effectively, for existing contracts. the phased and annual release of holdback that may exist under current contracts, those provisions don't evaporate for another year. The design professional lien right thing about holdback retention, presuming or leading to the presumption that there's lien rights, that got deferred, for example, until future contracts come about. So there's a short list of deferrals, but there are a lot of other provisions that apply today. And that's created a really interesting discussion, certainly among construction lawyers as of now, because I'll give you an example. Remember that holdback, it says holdback shall be paid at the end of the lien period. The problem up until now, it didn't say when it should be paid. As of today, it now says paid within 14 days after the lien period expires, provided there's no liens. Well, if the holdback was due to be released last November, and the owner today in January is still sitting on the holdback unreleased, the statute now says the owner has to pay within 14 days. And it doesn't say anything about that clause not applying. So you may be in a situation where you can knock on the door of an owner who's sitting on unreleased holdback and say the law as of now is you have to pay within 14 days. And that may be literally January 14th today is when that holdback is due to be released, because they can't say any longer, well, I'm going to get around to it, I'm just sitting on it. Now the law says you have to pay within 14 days. So they're offside payment starting tomorrow. So that these kind of transition rules, it's funny when, you know, the problem we identified with the earlier rules is they were way stretched out too long, almost in slow motion in terms of their adoption, prompt payment, adjudication, everything. This is the reverse. It's so quick. It's unclear how we're going to integrate the current rules with existing projects. But at least it's all for the benefit of contractors and trades on jobs, these changes ultimately. So that's all a very good thing. So that's what we wanted to cover. We've got a few minutes left in our time. If there's any other questions, I'll turn it back to you, Clive.
Nothing has come in yet, but I'll give it a few seconds here. Flip back and forth between the two question things here, but what do we got here? It's been answered. It does not appear that I have any new questions. So perhaps I'll turn it over to Mike to wrap things up.
Thanks, Clive. So a couple things. Thanks to everybody that attended. Here's what I'll tell you, Glenn. I'm amazed that a lawyer could keep my interest for over 2 hours. So fabulous.
Well,
fabulous.
Thank you for that.
Well, I have a short attention span. So great thanks to yourself, Kathleen from London, whose family is a member of the LDCA. That is so cool. And Clive for being our buddy for a number of years. Question for you, Glenn. Outputs to folks that were on. Is the presentation going to be made available to them?
Certainly, the association, your LDCA has a copy of it. We're absolutely
Okay.
thrilled if you could distribute it. As of course today demonstrated, this is all important stuff for everybody to know about. So happy for you to make it available to anybody who wants a copy. I see there's a question about the recording itself as well, and when it might be available. I'm sure that'll notification of that'll come through you in due course as well. So please feel free to distribute the presentation to anybody who needs it, wants it.
Okay. Thank you. And then to everybody on the call, recording was made, so there will be a full-on video chapterized, blah, 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 made available, and an audio recording made available. The other output that folks should be aware of, OCAA is doing an update to the layperson's Guide to the Construction Act, which we published in 2019. So you will get all of these in some language that you can understand. And I would say again, this, to me, it was Bill 60 is an improvement. I know Glenn indicates change in some of his presentation, but I would say across the board, it is improvement. And people should be very thankful for the great work that Glenn and everyone that was involved in bringing this into law. We should be very thankful to have a group of lawyers that care enough. They probably are well compensated outside of this, would also be my guess, but who are friends of the industry sufficient that they help make us a better industry. Because as you all know, with nation building and everything else that's going on in Canada, construction will become a very dominant part of GDP over the next 10 years. And it's good to have rules in place that can help this go as well as can be done. And to everybody else on the call, I would again reiterate this. This is the law of Ontario.
Yep.
Doesn't make any difference if they're a big American firm coming in trying to bull you, or they've got big manufacturing facilities and trying to bull you. This is the law of Ontario. And as Clive would say, there is a legal profession and there are your associations who are here to help you defend your rights, because being paid promptly is very important to everybody. So that's all I have to say. Thanks, everybody. Enjoy the rest of your day.
Thank you,
Thanks,
Mike.
everyone.
Thanks, Glenn,
Bye-bye.
Kathleen. Great to see you again.
Our
Till the
pleasure.
next time.
Thank you. Thanks. Bye-bye.